Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving wills, divorce, and remarriage, a key topic in wills and administration of estates under FLK2. Let's dive in. A man died recently, leaving a valid will that gave his entire estate to his new wife, whom he married 2 years ago. From a previous marriage, he had an ex-wife, divorced 12 years ago and now engaged to remarry, and 2 adult children. One is 30 and works in accounting, the other is 26 and works in advertising. The ex-wife is a full-time teacher. The new wife is worried that the ex-wife or the children might try to challenge the will. Under the Inheritance, Provision for Family and Dependants, Act 1975, what is the likely legal position? A. The ex-wife and both children are eligible to claim, but none are likely to succeed. B. The ex-wife and both children are eligible to claim, but only the ex-wife is likely to succeed as she was a spouse. C. The ex-wife and both children are eligible to claim, but only the children are likely to succeed as ex-wife will be remarrying. D. The ex-wife and both children are not eligible to claim as they are all adults. E. The ex-wife and both children are not eligible to claim as they are not financially dependent on the man. The best answer is A. The ex-wife and both children are eligible to claim, but none are likely to succeed. Under the Inheritance, Provision for Family and Dependants, Act 1975, certain people can claim if they were left out of a will, including an ex-spouse, if not remarried, and adult children. Here, the ex-wife is still eligible because she hasn't remarried. Being engaged doesn't disqualify her. The children are eligible because they are direct descendants. But to succeed, a claimant must show they need financial support from the estate. The ex-wife works full-time and supports herself. The adult children are healthy and employed. So, while all are eligible, none are financially dependent, making success very unlikely. Scenario 2. A man made a valid will 20 years ago, leaving his entire estate to his wife at the time. 12 years ago, he divorced her but never updated the will. 2 years ago, he remarried and now has 1 child, aged 18 and studying full-time at university. The ex-wife is now planning to remarry. The man has recently died without making a new will. His new wife wants to know who is legally entitled to inherit his estate under English law. What is the correct legal position? A. The ex-wife still inherits under the will, as it was never revoked. B. The new wife is entitled to the estate because she was married to the man when he died. C. The estate passes under intestacy rules, and the new wife and child will share the estate. D. The child inherits everything under the old will, as the ex-wife is now disqualified by going to get married. E. The new wife inherits under the will by automatic substitution of beneficiary. The best answer is C. The estate passes under intestacy rules, and the new wife and child will share the estate. The effect of divorce on a will. When a person divorces, any gift to the former spouse in a will is treated as if the former spouse had died on the date the marriage was dissolved. The rest of the will remains valid, but the ex-spouse cannot inherit under the will. The effect of remarriage on a will. Marriage generally revokes a will unless the will was made in contemplation of that marriage. Since the man remarried after making the will and there is no indication the will was made in contemplation of the new marriage, the will is revoked by the subsequent marriage. The intestacy rules. If there is no valid will at the time of death, because the will was revoked by remarriage, the estate passes under the intestacy rules. Under these rules, the surviving spouse, the new wife, and the child would share the estate. The spouse receives the personal chattels, a statutory legacy, and half of the remainder, with the other half going to the child. Scenario 3. A man made a valid will 20 years ago, leaving his entire estate to his then-wife and their son. 12 years ago, the wife named in the will died. The man never revoked or updated the will. 2 years before his death, he adopted a daughter when she was 3 years old. At the time of his death, he had not made a new will. The son is now 17 years old, and the adopted daughter is 5. The son now asks, A, whether he can receive the estate immediately, and B, whether the adopted daughter is entitled to any share. What is the correct legal position under English law? A. The son is entitled to the estate under the will, but it will be held on trust until he turns 18. The adopted daughter may have a claim for financial provision under the Inheritance, Provision for Family and Dependants, Act 1975. B. The son is entitled to half of the estate immediately, and the adopted daughter is entitled to the other half under intestacy. C. The will was revoked by the death of the wife, so the estate passes under intestacy equally and immediately to both children. D. The son will receive the estate immediately, but he must hold half of it on trust for his adopted sister. E. The son is entitled to the estate under the will, but it will be held on trust until he turns 18. The adopted daughter is automatically entitled to financial provision under the Inheritance, Provision for Family and Dependants, Act 1975. The best answer is A. The son is entitled to the estate under the will, but it will be held on trust until he turns 18. The adopted daughter may have a claim for financial provision under the 1975 Act. Validity of the will. The will remains valid because there is no indication it was revoked by marriage or other means. The death of a beneficiary, the wife, does not revoke the entire will. The gift to the deceased wife lapses unless there is a substitution clause. Son's entitlement. The son is a beneficiary under the will and entitled to his share. However, since he is 17, a minor, his share will be held in trust until he reaches 18, the age of majority in England. Adopted child's position. Adopted children are treated the same as biological children under English law for inheritance purposes. However, since the adopted daughter was not named in the will, she does not automatically inherit under it. Financial provision claim. The adopted daughter may have a claim for reasonable financial provision from the estate under the Inheritance, Provision for Family and Dependants, Act 1975, as a dependent or family member, especially given her young age and the fact she is a child of the deceased. This table outlines the legal principles we walked through. In Scenario 1, although the ex-wife and adult children are eligible to claim under the Inheritance, Provision for Family and Dependants, Act 1975, they must prove financial need, which is unlikely if they are independent. In Scenario 2, divorce cancels any gift to the ex-spouse, and remarriage revokes the entire will unless it was made in contemplation of that marriage, so the estate passes under intestacy to the new wife and child. In Scenario 3, the will remains valid despite the wife's death, but her gift lapses. The minor son's share is held on trust until he turns 18, and the adopted daughter may claim under the 1975 Act if not named in the will. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE 1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.